let's get it right. I thought he has a conviction.
There's two. There's an assault to third degree from September 11th of 2019 in the indictment, and then a prior one, attempted robbery, third degree, March 28th, 2013.
Yeah, I was looking at the unlawful possession of a firearm indictment. I don't know that both of those are priors were included in that particular.
No, it's not. It's not, Judge. It's just as one of them in that case. I looked at.
But if there are two, I mean, you would
Right.
file that notice,
Right.
so it would be considered habitual,
Yeah.
correct? Okay,
Eventually I will.
okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
And Mr. O'Veal, in cause number 25 DCCR 1776. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025.
Here's where criminal history starts changing the entire game. Most people hear a new charge and focus on the alleged offense. Judges focus on the record. And in Texas, prior felony convictions can transform a case from serious to life-changing in seconds.
That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done.
Think about what just happened. The defendant isn't being warned about what he already did. He's being warned about what could happen if a jury finds those prior convictions true. That's the power of sentence enhancements. The crime stays the same, but the punishment exposure explodes.
You're charged with a third degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is it.
oh, I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you? And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you. Mr. Coleman, Mr. Adams is unable to be here this morning on John Lamel, so we'll reset John Lamel. All right, good morning, sir. You're Lenny Ledette. Ledette, I'm sorry. And Mr. Ledette's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Thanks, ready, Your Honor.
Judge, we're ready, subject to the case that I have set in another county, and I've spoken with him about it.
All right, so I'm going to contact that county, kind of see where we stand after this. I want to make sure we're all on the same page because after today, there won't be any plea negotiations or agreements. And it looks, have there been any new negotiations or?
Yes, Your Honor. Last week I filed a notice of enhancement using his prior to enhance if he's convicted of this offense, his punishment range will be that of a first degree. So at that time, I made an offer for him to plea open to a second degree, just under the indictment count one.
All right.
And I believe that's been rejected.
And it looks like that prior that Mr. Nichols filed is regarding an aggravated robbery from September 27th of 1997. And so I'm sure Mr. LeBlanc has gone over with you, Mr. Ledette, that if you're found guilty in this case and that prior conviction is true, that would enhance your punishment to that of a first degree felony, which is between 5 years and up to 99 years or life in prison. You understand?
Yeah.
And do you want to reject that and go forward with your trial?
Yes.
All right, I am going to number this case, the number one case. It's obviously the oldest. Mr. Ledette's in custody. It's time to get it moving. I will contact Judge Thomas and see how, if we can work that out, and we'll let you know today between he and I and who kind of wins out on that one. Okay, so we'll do our best to get your case tried next week. All of who gets which attorney depends on the type of case, age of the case, if the defendant's in custody, and all kinds of things. So I'll talk to Judge Thomas and we'll get that figured out today.
No, it won't be no recess.
Well, if Judge Thomas wins, depending on age of case and type of case, then yes, there would have to be a reset because Mr. LeBlanc can only be in one court at a time. If I win, then we get them and we try your case next week. So we'll find that out today. I'll talk with Judge Thomas. I'll do the best I can. I'll want your case tried this next week as badly probably as anyone. It's one of the oldest on my docket, so it's time to get it taken care of, obviously. So I will do my best to get Mr. LeBlanc here next week, and we'll know that today. Okay? All right, go back with the bailiff. Good morning. Are you Howard Walker Jr.? And Mr. Walker, in cause number 26, DCCR 0082, you're charged with a first degree felony offense of injury to a child from December 16th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment is 5 years up to 99 years or life in prison. Do you understand? And I have here on the
Notice the prosecutor's wording here. The offer isn't just based on the charge, it's based on the extent of the child's injuries. If new medical evidence shows permanent damage, the negotiation landscape can change overnight. In criminal court, facts don't just determine guilt. They determine value, risk, and strategy.
tablet, a document called the plea bargain rejection that has your signature on it with Mr. Parker's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 30-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Nicholas, is there any reason to believe that, are you waiting on any evidence?
Judge, that offer is based on the injuries sustained by the child, a 1-year-old with facial fractures and lacerated liver. I need to get some follow-up medical records to see if that condition has improved or if it's going to be a permanent injury situation. That offer may get worse depending on what I find.
Okay, so I do want to make sure you understand, Mr. Walker, that after today, I will not accept this plea agreement unless there's some new evidence that comes to light from your attorney or the state's attorney. Do you understand?
Yes, ma'am.
All right, and so also, Mr. Parker's been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Walker, we will appoint someone today, and they should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Good morning, you're Jaden Simon.
Yeah, ma'am.
And this is 25 DCCR 1760. Mr. Simon's charged with aggravated robbery, and 25 DCCR 0918 charged with robbery. So the first one's aggravated robbery, second one is robbery. And what is the announcement?
Judge, he's rejecting the previous offer. It was 20 years. I told him that he could go and agree to the court, and also told him that because he wants probation, I also told him that the prosecutor is saying that they will, if they have to try it, they will ask for consecutive sentences.
That's exactly right.
So the offense dates are on two different dates. It looks like the first one was from June 12th of 2025, and then the second offense date from October 10th of 2025, which means if you're found guilty in both of those cases, it is possible the state would ask, and then it would be up to me whether or not I would run any sentences consecutive or concurrent, which means either stacked or not. So that would be up to me. It looks like you previously rejected, and this rejection might have been before. So it was 20 years in both
Yes,
to
sir.
run concurrently. Is that correct?
Yes, Your Honor.
So the offer is a 20-year sentence in each of your cases to run concurrently. You want to continue with that rejection and move forward with trial. Is that correct?
Yeah, ma'am.
Okay, we'll get it set on the trial docket, and Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff.
Thank
Good morning. You are Judson Jermaine Bell.
Yes, ma'am.
And Mr. Bell has three cases, 25 DCCR 0108, 0109, and 0110, all set for trial to begin with jury selection next Monday. And what is the announcement?
Right here. State's ready.
And what is the intention with regard to, it looks like it's all the same offense date. What's the state's intention with regard to which case or all cases?
We'll be trying the evading case.
Okay, all right, so that is 0109. I will number the case today after docket and let you know after lunch
Yeah.
today. I do want to, it looks like there's been plea bargain rejection on file for some time. That was for a